are conventional mail in connection with directives.
Lordship, may I next month. Lordship, may I permit to mention an application for non-prosecution, Lordship? Matter for non-prosecution.
Non-prosecution of what? Appeal? Criminal appeal?
Bail application, Lordship.
Lordship, may I permit to mention appeal hearing, Lordship?
Next month.
May I permit to mention? Lordship, in 16/4/2024, your Lordship pleased to release the petition on bail, but the difficulty is that for the inadvertent mistake on behalf of the advocate on record, the name of the police station is mentioned here.
Take out an
Durgapur,
application.
instead of
Take
Hon'ble.
out an application.
Who already
File.
he has already filed an application.
Yes.
My lord, may I permit to mention bail in connection with the appeal? The petition is now 14 years in custody, your lordship.
May.
May I permit you to mention admission of appeal?
Relaxation of condition of bail. Admission of appeal.
And for correction of order.
Yes, call the list.
Hi, proceed.
Number 1. Now they are clear for this.
Well, unfortunate. The report your lordship will see, the chief judge has written to your lordship because of the strike.
What can be done?
Let's just see what they have done.
What can be done?
My lord, your lordship style, my lord. Contempt, Kuldev, Murshidabad, what your lordship did. Baharampur bar, my lord.
And Mr. Mukherjee,
Yes, my lord.
what is the demand considered?
Can you
Is
think
it
about it?
possible?
Water. Water.
No, not water.
Only.
The crux of the demand is when there is a warrant and an accused is to surrender, he will surrender through video conference.
Oh, I didn't know that. Achha.
That's
Then,
not
but
it.
then, my lord, your lordship has to strike hard, my lord.
Now, my view was if it's a summons,
Then it can be done.
we can, if it is a summons. If it's a bailable warrant, still then we can, with an undertaking that you file the bond within 48 hours. How can it be for a non-bailable warrant?
No. It can't be.
Because the man has to be arrested.
And then produced.
First order is what? Person
Taken
is
into
taken
custody.
into custody. How do I take a person in custody who is
Virtual mode.
accessing virtually? The word arrest even today means touching the body.
Yes.
Then it is that spatial closeness must be there. So the chief judge asked for a response. I gave a response that other cases can be considered, but so far as non-bailable warrants, it's not possible. It's not possible to have electronic or video conferencing appearance. That set the fall ruling. Now what they are saying? Water. What water is there?
Water is not there. Wi-Fi connections is not good.
So if you don't work, will they become better?
That's
Water we can immediately.
not only that, my lord. What happened, my lord? We were appearing.
It's really painful. Why?
And in the PMLA Act court, my lord, we were appearing.
Who is now the secretary there?
Chobe.
Chobe, our
Yes, my lord. But I think it's not you summons him once. That will solve all of it.
Devashish Junior.
Call him.
Why only one person? Ask him anything he's doing.
But
Chobe is now secretary.
how do you call him?
You ask him to be president.
Okay, my lord.
We'll pass in direction.
Yes, madam.
Who is the secretary and who is the how many bar is there? Let them be first personally.
Three bars.
We are not issuing a rule of contempt. We'll request them to be personally
To
present
be person present.
and explain the conduct of the bar associations in causing cessation of work.
Correct.
Let us
কি বলছেন আপনি কিছু বলার আছে?
how many bars are there?
Three bars. লিখে দে না তিনটে বারের।
কি নাম আছে লিখে দেন
লিখে দে। তিনটে বার লিখে দে। দে। যেটাতে বিষ্ণুদা বসতো হ্যাঁ জানি বিষ্ণুদা বসতো
Petitioner is an under trial who has been incarcerated for
more than 4.5 years.
4.5 years, while rejecting his bail plea in when?
On January 29th of January.
Supreme Court?
Your Lordship's order and all subsequent orders of the trial.
না না সুপ্রিম কোর্ট অর্ডারটা বল ডেটটা হ্যাঁ 6 months মানে these are the 3 bars
While rejecting the bail prayer
in January. January 29th or something.
23.
now we refer to that Supreme Court order.
না হ্যাঁ যদি 30th
Hi, Supreme
ব্রিফটা আনি
Court did order.
The Supreme Court order was 17th of March 2023.
Now, while rejecting the prayer for transfer of the proceedings in transfer petition criminal number 409 of 2021, the Apex Court inter alia directed the Chief Judge City Sessions Court to take up the trial on a weekly basis and make an effort to conclude the same. When was this order passed?
which one মানে
The Honorable Apex Court.
March 24
17th March
Acha,
2023.
by order dated 17 March 23, directed the trial to be concluded, to conclude the same within a period of 6 months. In an earlier bail application, niche diye diyo CRMDP, this court, by order dated 29/1/2024, passed the following directions. Paragraph 11, full stop. Unfortunately, directions. In the present bail application, report has been filed. Report has been filed by the Chief Judge City Sessions Court today, disclosing the status of the proceedings. In the report, the judge observed that trial could not proceed. Observed, though witnesses were present, observed, though CSW 32 Afzal Ali Shah was present, he was prevented from entering the court compound as the 3 entrance gates of the court compound were locked. The report clarifies. The report further further records that the stalemate, that this situation arose due to the resolution taken by the bar led by the secretary and president. Full stop. It may be worthwhile. They had threatened to they threatened the court that they would stall the court proceedings and prevent the witnesses from adducing evidence. They would stall court proceedings. They would lock all entrance and exit gates, prevent judicial officers, staff, witnesses, litigants, and UTPs from entering or exiting the court, and thereby disrupt court proceedings. Full stop. The report prima facie discloses acts unbecoming of members of the bar, which tantamount to interference or obstruction to administration of justice, punishable as criminal contempt under section 2C of the Contempt of Courts Act. However, now this notwithstanding the conduct of the members of the bar and their office bearers, as noted in the report, we feel better senses will prevail, and the members of the bar and the office bearers of the bar associations would be able to resolve the dispute, would resolve issues through dialogue and negotiations instead of disrupting court proceedings and holding the court at ransom. Full stop. We direct the members of the office bearers of the bar associations to convene within office bearers of the bar, the president and secretary of the 3 bar associations, namely, please give us the names, to convene a meeting of the association within 48 hours and take a resolution and take a decision to participate in the court proceedings. Full stop. Participate in the court proceedings. Grievances, if any, the associations may forward their grievances through the Chief Judge City Sessions Court to the Registrar General of this court, and the matter may be discussed, and the matter may be discussed and resolved through negotiations under the auspices of the learned Registrar General. Under the auspices of the learned Registrar General. Full stop. Under the auspices of the learned Registrar General, it is we are of the firm belief no problem is insurmountable if a positive and constructive approach is taken by no issue relating to administration of justice. We are of the firm belief all issues. We are of the firm belief a constructive approach by all stakeholders would help to resolve issues, if any, and enable the smooth functioning of the courts. Full stop. We hope and trust better senses will prevail, and the court shall not be embarrassed to take harsh steps in the matter, like initiation of contempt proceedings against the members of the bar. Full stop. Report with regard to the issue, further report in the matter be filed by the Chief Judge Sessions Court and the Registrar General on the adjourned date. Matter will come on Monday. Let us see
Yes,
how they
Monday, I'm giving the names of the
copy.
secretary and the president.
Department shall communicate this order. Department shall communicate this order through to the President and Bar Association, President and Secretary of the Bar Associations in the course of the day. In the course of the day.
I'm going to do this.
Full stop. as well as the Registrar General and Chief Judge in the course of the day.
My lord, I'm giving the names of the
Uh,
president and the secretary.
They are expected, full stop. We'll take it up on Monday.
Grateful.
We hope, Mr. Mukherjee, there was no progress since the time.
No, there was one, Anisur was doing the cross-examination himself.
Okay. Already then.
60 witnesses have been
16.
examined.
Because your lordship said 18 to be examined by
More than
30th.
that.
I think around 16 have
Witnesses have already been
That
examined.
is good enough.
16 is going on. Today I spoke to the learned public prosecutor in the morning. 16 is going on.
16th.
Only one vulnerable witness is
16th
left.
is going on. Of the 16th is going.
Let them take the call.
Yes,
Thereafter we will.
Grateful. Grateful.
But Monday, let us see.
Right.
But this
Has to
trial was going on.
Yes, yes.
But the CS
all the
32 was
orders-
stopped.
Because my lord, nobody could enter. That is the reason
But
why.
most of the impasse that is happening, my lord, your lordship will see. I have filed the, my lord, order sheets. Page 99 onwards, everything is recorded in the order sheets of this trial.
Yes.
Of this trial. To the extent that, my lord, the main witness, my lord, the victim, my lord, on the date of his deposition, my lord, he was locked in the court premises.
That is what I'm saying.
And these are reflecting in the order sheets which I have, my lord, just
My
submitted.
lord has got it in the report, my lord.
I've seen that. CSW, the
32.
32.
32.
He is the victim.
he couldn't enter.
He
No, he
entered
entered,
the
but
courtroom, then it was locked from
Locked
outside.
in-
Ota Bolaji could not, CSW could not enter now. Was locked in the court premises.
দিয়ে দিলি সব নাম জানিস জেনে না ফোন করে জানিয়ে দেন ফোন করে জেনে নেন গ্রেটফুল ম্যান
Great. দিয়ে দিচ্ছি পুরো বাঞ্চটা দিয়ে দিচ্ছি
এটা টাইপ করে দাও
100 কত পাতার একটা bunch
সাইন ইট
Great.
আরে ওই রিপোর্টটা থেকে দেখ রিপোর্টে লেখা আছে রিপোর্ট থেকে আমি কোট করেছি নেক
Great.
My lord, earlier occasion, this matter was adjourned as 18th and 19th were the date fixed for evidence. My lord, on those days, one witness was present, but my lord, the could not be examined as because the court was on leave on both the dates. My lord, these are the order sheets.
How long you were in custody?
My lord, 2 years and 3 months.
How many
Just,
witnesses are
get
there?
the report.
Petitioner is in custody for 2 years and 3 months. He submits. There is delay in trial. He prays for bail. On a lawyer, learned Deputy Solicitor General submits report. He contends on the next or the last schedule. Witness was present, but could not be-
One witness was present.
one witness was present, but
2 days were there, Millard. One day on the 18th, we were produced the first witness, that is witness number 2. And next day, we were supposed to produce the next witness. That is on the 19th. But since the learned presiding officer was
Right.
not there, asking him to come, and we knew that on both the days he's on
Right.
leave.
witness could not be examined as presiding officer was absent. We have considered the materials on record.
Millard, he is the person
From
who was
one-
the driver, Millard, and
How
from
many
whose
witnesses are there?
5 witnesses only, Millard, and it would have been examined on these 2
We
days.
have considered the materials on record. 1 kg of heroin was recovered from a
No,
truck.
Millard,
No,
no,
my
Millard,
lord,
no, no,
7
no, no.
packets, each
Seven-
containing
Oh,
1 kg.
7 kgs.
7 kgs, Millard.
7 kgs of
Lordship will
heroin
kindly
was
see
recovered
paragraph
from
6.
from a truck. Petitioner was driving the truck.
Was the co-driver, my lord.
Was one of the drivers of the truck. Full stop. Trial is in progress. 1 witness has already been examined. Full stop. Last schedule examination of witnesses could not take place during the last schedule as presiding officer was absent. Prosecution cannot be made responsible for this delay, and as prosecution assures this court to conclude trial within 6 months from the next date fixed for recording evidence, subject to cooperation by defense and systemic delays. We have, in view of the aforesaid assurance, we are not inclined to grant bail at this stage. We request the trial court to expedite the trial and conclude the same at an early date in light of the assurance given by the prosecution. Parties shall cooperate with the trial.
Indebted lordships.
could not be examined as presiding officer was absent. Yes,
That's the last of the adjourn this matter. Now, out of 10, 7 witness were examined. Petitioner is the case 3 years, 7 months. And time frame also expired. Kindly see the
7
On
witnesses.
the last occasion, one of the investigating officer was examined. One is left. 4th May is the next date.
3 months.
My lord, 3 months.
Petitioner
4th May is
submit. He is in
time
custody
frame
for
also expired.
3 years and 7 months. He prays for bail on ground of delay in trial. Learned lawyer for the state submit. Prosecution witnesses, examination of prosecution witness is almost complete. 7 witnesses have already been examined. Investigating officers are being presently examined. We have considered the materials on record. Narcotics above commercial quantity,
1 kg brown sugar.
One case.
that is 1 kg heroin was recovered from petitioner. Only one
My lord, 3, the others 2 were not, it was not recovered from them.
from petitioner, full stop. Trial has substantially progressed. 7 witnesses have already been examined. Prosecution assures this court that trial shall be completed within 3 months from the next date fixed for recording evidence, subject to cooperation by defense and systemic delays. We have, in view of the aforesaid, we are not inclined to grant bail at this stage. Trial be expedited in light of the assurance given by the judge. Hello, rejected.
And also we give it.
2.5 years I'm in custody. My lord, on the last occasion, your lordship asked for a report. And my lord, page 29, my lord, at page 29, lordship will find the Caesar witness did not support the prosecution case. In his presence, my lord, the fact number.
We have considered the materials on record. Learned counsel submit. He is in custody for 2 years, 5 months. Independent witnesses did not support recovery. He prays for bail. Learned lawyer for the state submit. 5 out of 7 with prosecution witnesses have already been examined. We have considered the materials on record. Trial 1,680, 15,608 cough syrup containing codeine phosphate of commercial quantity was recovered from a vehicle. Petitioner was in the vehicle. Trial is in progress. 5 out of 7 witnesses have been examined. Official witnesses have supported the recovery. Official witnesses have proved the recovery. Impact of independent witnesses turning hostile requires to be assessed in the light of other evidence on record.
The next date is
In conclusion of trial, prosecution assures this court that trial shall be completed within 6 months from the next date fixed for recording evidence without subject to cooperation by defense and systemic delays. Under such circumstances, we are not inclined to grant bail or same order. Yes. কোন বার অ্যাসোসিয়েশন গুলোর নাম দিতে হবে?
This is the report, my lord.
তুমি ওই সৌমেন
This is the report, my lord. The state file 1311 application, my lord, for recalling the PW9, my lord. 25th the date fixed for, my lord, the witness, my lord. We need 1 or 2 months maximum, my lord. Petitioner, my lord.
Vehicle मिला, petitioner present मिला.
435 kg of ganja, my lord. Keep going.
My lord, next matter is that matter where the petitioner was first implicated in a 379 case, where I produced document about ownership of my vehicle. Thereafter, my lord, that report were not produced. I was enlarged on bail. I was pursuing for my legitimate right in respect of the vehicle. My lord, thereafter, police officers started coming to my house, threatened me. My lord, I lodged a complaint before the concerned magistrate, before whom the matter was pending. Within 10 days, I was implicated in an NDPS case. Not only that, my lord, in this case, I am in custody for no videography was asked.
Was in 2021, my lord. Videography was not done, my lord. My lord, three witnesses has been examined. PW1 was complete. They filed an application for recall of that witness, my lord.
My lord,
Out of 12, 3.
936 days. And also, my lord, near about 3 years, my 940 days, my lord. Please.
No, my lord. It's almost 4 kg.
My lord, joint position.
3.95 grams. Bas. My lord, 12.
Okay, 7 and 8 are together. 8 lordship already granted bail to the co-accused on 18th April. Petitioner is the same.
Yes, yes.
disposed of.
2 years, 3 months. Great.
Number 9.
My lord, 9, I am for the petitioner. My lord,
For the state, my lord.
599 bottom.
God. Achik.
My lord, I'm for the petitioner, my lord. My lord, 599 bottles of fentanyl, my lord, was seized from one Rikul, my lord. My lord, he has been my lord, after his arrest, my lord, on basis of his co-accused, the statement of the co-accused, my lord, we were implicated. My lord, charge sheet has been submitted in this case, my lord.
Only thing is that, his anticipatory bail prayer was turned down by High Court.
ED.
It was turned down by Supreme Court. Now, subsequently, he surrendered on 12th to 2024. And my date has been fixed for evidence.
70 days. Petitioners, my lord, two petitions. Deeply.
My lord, I am for the petition. My lord, from a vehicle where one Joydev Mondol and Obhijit Chakraborty were traveling, 44.8 2 kgs of ganja was recovered. My lord, this petitioner's name transpired from the statement of co-accused person. 44.2 kgs of ganja. And my lord, this petitioner's name transpired from the statement of co-accused person. One of the co-accused person, Choyon Mitro, his prayer for bail was rejected by this honorable court as there were fund transfer and CDRs with the arrested accused and Choyon Mitro. But so far this petitioner is concerned, my lord, to my instruction, it is only on the basis of co-accused.
Page 142, my lord. There is some CDRs and my lord, the bank statement which states that my lord, they have my lord some. But regarding that, my lord, need some file to report, my lord. They get a specific report, my lord. My lord.
My lord. Great future. 1 week. Great future. No.
My lord, I am for the petitioner. My lord, this petitioner is in custody for 260 days. My lord, this petitioner deals is having a business of khaini, my lord. Yes, my lord. He never transports or consigns things through couriers. His company's name and the labels has been given in this courier by one Shantanu Banerjee, my lord. He is an employee of this petitioner, my lord. 89 kgs of poppy straw has been seized, my lord. The charge sheet has not been submitted till date, my lord.
My lord, poppy straw dust in two packets. No, that's not the case. I mean, look at the report. He has done it 23 times, sending it to my lord Chandigarh, and my lord by courier, a noble way of trafficking. And my lord, by 180 days, I have made the prayer that was extended by the learned trial judge. Now he is in custody for 210 days. All right, and he has a my lord, previous case which has been filed before the Chandigarh on 7th of March 2024. But we have recorded the name of Sanction. The next date is tomorrow for filing the report before the learned trial judge. I can produce the case date. Yes, my lord. Definitely, my lord. Definitely. Directly, I have to be present in court with the case date.
Two hundred and 60 days. No, 210 days. Ulta lekha. 260 days, my lord.
डायरेक्ट आया थी प्रेजेंटिंग पे
मैं बोल grateful.
My lord, 12 for the petitioner, my lord, 69 bottles of fentanyl was seized from me. My lord, I am in custody for last 2 years, 3 months, 22 days, 10 witnesses. My lord, no trial has been started
2
yet.
years, 3 months, there is no progress in trial. He prays for bail. Learned lawyer for the state submit. Charge has been framed. Date has been fixed for recording evidence. We have considered the materials on record. Though 69 bottles of penicillin syrup was recovered from the petitioner, only one person.
Only 1%.
From the petitioner, comma,
My lord, from these
there
cases,
is
my lord,
inordinate delay in trial. No witnesses have been examined. Delay cannot be attributed to the defense. Prosecution proposes to examine 10 witnesses, and there is no possibility of trial concluding in near future. Under such circumstances, we are inclined to grant bail.
I'm grateful.
Petitioner, while on bail, shall remain within district Rani Nagar and report, except for attending court procedure, and report to officer in charge Rani Nagar. Next. Police station, within police station.
So I'm for the petitioner. Worship, petitioner was in surrender. He was both are custody 90 days. Worship, other co-accused are acquittal in this case, Worship.
So what?
Worship, kindly see the order sheet.
Petitioner had absconded and was declared a proclaimed offender. Trial is in progress, hence we are not inclined to grant.
Not really.
But I am for the state.
Let's say I for the petition. Let's say claiming parity last week.
The co-accused have been granted bail on similar footing on 16/4/2024.
Delay.
PRM NDPS 663.
How long you are in custody?
3 years, 9 months.
Petitioner is in custody for 3 years, 9 months. There is inordinate delay in trial. Under such circumstances, co-accused so and so has been enlarged on bail. Petitioner is entitled to similar treatment. Yeah, similar treatment. Next.
My lord, in this case, I am appearing for the petition. It's a renewal application, lordship. Lastly, the matter was rejected on 23rd of February 2023. Page 10 of my application. My lord, custody is about 1 year and 10 months, 666 days. Allegation recovery of 121 kg of ganja. Both the petitioners are the driver and no progress of trial.
Trial is in progress.
Last 3 days.
Circumstances, we are not inclined to grant bail to the at this stage. Next.
I am for the petitioner, my lord. 24 kg, 300 gram of ganja was recovered from 3%. I was the driver of that vehicle.
How long you are in custody?
7 months.
But charge already framed, my lord. Date for evidence is fixed, my lord.
Petitioner is in custody for 7 months. He submits he has been falsely implicated in case for bail, and a lawyer for the state opposed the bail prayer. We have considered the materials on record. 24.3 kgs of ganja was recovered from petitioner and 3 others. trial is, charge has been framed or
Charge frame, my lord, date for fixed for evidence, my lord.
it has been fixed for recording prosecution evidence
11
under
July.
the circumstances and in view of statutory restriction 37, we are not required to grant.
I am for the statement. Commercial quantity, my lord.
My lordship, I am for the petitioner here. This is the second bail application. In the
Yes, it-
last bail application, my lordship, the petitioner has been, like the prosecution has been granted 1 year time to conclude the trial. My lordship, nearly 3 years, 6 months has already passed, my lordship. Out of 16 witnesses, like a 10 witness in the main charge sheet and the 6 witness in the supplementary charge sheet, my lordship, only 3 witnesses has been examined so far, my lordship.
Oh, my
Most
lord.
important part is that, my lordship, this was the COVID time. I have nothing because the main accused has died, my lordship, in this one. The person who was a receiver, he has already died. And the truck owner already, he has been arrested and there is a confession on the truck owner that is there. My lordship, my role was there only because it was a COVID time. There was no vehicle available to come to Calcutta and I was just into that vehicle, my lordship, that is there. Now,
6,000.
even after 1 year, the court has given.
Have you finished?
My lordship, only one thing, my lordship, I want to say the last time also the court has given 1 year time. In the only 1 year, 2 witnesses has been examined. This is what the progress of the trial. There are 16 witnesses are pending, my lordship. That is there.
Petitioner renews his bail prayer. He contends, in spite of direction given by this court to conclude trial within 1 year in March 2020, in CRM NDPS 502 of 2023, only one witness trial has not come to an end. He full stop. State shall submit report with regard to the status of the proceeding, reason for delay, and a timeline within which they propose to conclude trial. Adjourn 1 week.
Oblige, my lordship.
18, my lord. Before the read code, my lord, I have made out a case of false implication. My lord, your lordship kindly sees my page 21, my lord. When police raided my house in search of my father, my lord, they failed to, my lord, intercept him. My lord, then, my lord, they have, my lord, taken me away from the house, kept me in the police ferry for 2 days. Your lordship kindly sees I have a document to show in page 33 and 34. If your lordship kindly sees the information to the police received and a general diary was registered, it is referring in respect of formal FIR 370, but in the letter of complaint it says 358. Your lordship kindly sees, and in page 21, immediately my mother moved before the red court, saying that CCTV footage of the police station and ferry should be preserved immediately.
The report is here, Your Lordship. They have given 2 mobile numbers saying that, and both the mobile numbers, the information of for both
What
the mobile
was
numbers
recovered
there.
from him?
On both the days, the
What was recovered from him?
508 grams of heroin, Your Lordship.
508 grams of heroin. Where?
From the street, Your Lordship.
From the street.
From the street.
You had a videography of the
The
recovery?
Caesar was videographed, Your Lordship.
Caesar was videographed.
And the mobile phone location is also there.
What is
all
that?
the time he was near his house, like the 2 days when he was talking about.
So that
Near
is
his
mobile phone location.
house.
The mobile phone location.
So if your mobile phone is now in High Court Calcutta,
My mobile phone is at High Court Calcutta.
we will get a tower report which will show that you are in Maida. All right. This location has zero relevance with regard to space and time.
It is their allegation, Your Lordship.
Correct.
In the writ petition, it is their allegation that I was in the police custody for 2 days. Whereas as far as the mobile phone location shows, he was somewhere near his house only.
Mobile phone may not have been taken with him. Who says that he was taken with the mobile phone? How does a mobile phone help you when a person is being illegally detained?
Your lordship, they only said in the writ application that the mobile phone was with him only.
They have said that.
Yes, your lordship.
You give a further report with regard to his allegations. Petitioner submits that he had been illegally detained in the police station on when?
Malad, on 9th, Malad, I was taken away from my home.
All right, on 9th of
October, Malad,
9th of October 2023.
And Malad, the information, Malad, the first information received by the police, as it appears from the general diary, when it was noted in a general diary, it appears from the FIR is 370. And Malad, in the later, Malad, letter of complaint, it says Malad, first information received and it was
When was the seizure made?
seizure, Malad, on that day, Malad. As per the FIR, Malad, 9:15 hours on 9/10/2023.
9/10?
2023.
9:15
when were you taken
in the
away?
night.
When were you taken away from your house?
Malad, in the morning, Malad.
Petitioner contents in the morning of 9/10/2023. Petitioner was taken away from his house and illegally detained at the police station.
8
After
a.m.
he was
8:30
falsely implicated in the case, alleging recovery of 508 grams of heroin from his possession at 9:10 hours of the same day. Stop.
Your lordship.
There is incorrect recording with regard to the general diary in the letter of complaint. Incorrect recording with regard to the number of the general diary number with regard to the general diary number pertaining to the prior information in the letter of complaint. He moved this court under Article 226 of the Constitution.
My mother.
His mother moved this court under Article 226 of the Constitution and presently he prays for bail. Learned lawyer for the state opposed the bail prayer. Yes, what do you say?
Your lordship, this is a content of the general diary. It is absolutely correct, your lordship. It says that 358, general diary number 358, they received the source information.
Right.
And 370
Is the after coming after the raid that 370 was recorded?
Your lordship.
The learned lawyer for the state opposes the bail prayer. He submits prior info general diary number 358 dated 9/10/2023 pertains to prior information, whereas general diary entry number 370 on of the same date pertains to the registration of the FIR after recovery.
And your lordship, as per the FIR, the recovery was made from Bagchi Primary School and not from his house.
Mobile phone location.
Barnia Road,
Mobile phone location of the petitioner shows he was at his residence and not at the police station at the prior to the occurrence.
He was not at his residence, your lordship. He was going on bicycle at Barnia Road.
All right. Mobile phone location of the petitioner at the time of recovery.
At the time of recovery, he was on his bicycle. And
so how does it help you with regard to the illegal detention?
No, he was never illegally detained.
That is his contention, correct? You are trying to dispute that contention, break that contention by referring to a CDR. Your reference to the CDR is with regard to the place of recovery. What is the CDR tower location in the early morning of the 9th? That will improbabilize if the tower location of the police station is not that where his mobile phone is. Because if he is in your custody, you will physically take him to the place and show the recovery.
We'll file a further report, your lordship.
Learned lawyer for the state submits seeks time to submit report in response to the plea. 1 week.
Much obliged.
में अगर ले गया तो सुबह का क्या CDR है वो देखो 9:30 में तो उसको कान में पकड़ के ले जाए He's a new cure. Yes, next.
My lord, my application, my lord.
I will state, my
That I'm in custody for 160 days, my lord. Nothing was recovered from my possession, my lord.
Nothing recovered.
Nothing recovered.
CDR is there.
Yes,
CDR is there.
no, my lord. But only one recovered from the Gulab Rasul, my lord.
My lord, Caesar is from Ghulam Rasul. He was on the
Can you hear what we are saying? Please explain to him.
no seat.
Nahin to.
Phone call records.
No, my lord, no, I'm still no.
Nothing was.
Still no.
How does its complicity come out?
I'm still not the Ghulam Rasul.
Statement of Ghulam.
Only. No CDR is there, my lord.
Yes. Petitioner is in custody for
160 days. My
160 days. He submits that he has been for. You are absconding for 60.
lord.
Yes, sir.
My lord, I am in the similar circumstances with that of the Rohim Sheikh, my lord, at page 12. Your lordship granted bail, my lord, to that accused
Rohim was
person.
arrested in another case.
Yes, my lord, I was also. My lord, this is the certified copy. This is the server copy of your lordship's order, my lord.
When were you arrested?
I was arrested. I have surrendered in 2019, my lord. 2020,
November.
2020.
23 after 8 years.
And after I have suffered custody for 3 months. Subsequently, I was enlarged on bail by this honorable court, my lord. My lord,
So what
the
about
prosecution has not.
what about 2015 to 2020?
My lord, I was not aware. I have not even
Alright,
applied
petitioner-
for 438 application also, my lord.
All right. Petitioner is in
My lord,
custody for
160 days.
160 days. He contains no narcotics, was recovered from his possession. Co-accused Rohim Sheikh has been enlarged on bail. Learned lawyer for the state opposed the bail prayer. He submits petitioner does not stand on the same footing with Rohim Sheikh, who was in custody in another case.
My lord, I was also in custody in another case of the same police station, my lord.
Petitioner, in response, petitioner submits he was also in custody in another case in 2020, but was not shown arrested in the present case. We have considered the materials on record. No narcotics was recovered from the petition. In 2020, he was arrested
23
in connection with another case in the same police station. However, he was not shown arrested in the said case. This shows indifference on the part of the prosecuting investigating agency to apprehend the petitioner and send him for trial. Under such circumstances, we are of the opinion petitioner is entitled to bail allowed 10,000. Next.
22. Lordship, in this matter, I am appealing for the petitioner. Is the renewal application, a custody is about, my lord, 1 year, 7 months, 575 days, and allegation recovery of 22 kg ganja. Lordship, in the month of August 2023, only 2 witnesses examined, and thereafter so many dates gone. Out of 13,
We have
only 2
considered the
witnesses.
materials on record. Bail prayer of Pallab Senapati was turned down in September 2023. Trial is in progress. Quantity of narcotics seized is above commercial quantity. Under such circumstances, we are not inclined to grant it. Next.
My lord, on the
in 22, I appeal for the petitioner.
my lord, on the last occasion, my lord, this relates to those post-poll violence. My lord, on the last occasion, your lordship had made a query whether in this case, there has been any threat to any witness or any other person having interest. And 3 of the vital witnesses have been examined already prior to the grant of stay by the Honorable Apex Court. Your lordship, from the order sheet will appear that your lordship had directed in the month of February that they be examined. Now, these are the depositions, and if your lordship kindly sees, we were members of the assembly only. The fatal blow was dealt by 2 other persons who are not before even your lordship. Kushai and Pappu. And we are in custody for more than 2 years, 8 months. 73 witnesses, only 3 examined till date.
2 years, 9 months, 4 days.
All right. Petitioner is in.
There is no date perception, but tomorrow is the date fixed before the honorable appellate court.
Tomorrow?
Tomorrow.
Monday. Monday. We're keeping this on Monday.
Same, actually the whole.
Same.
They were supposed to give
Where
us-
is the report? Same case though?
Yes, no, different, yes, same case. Same case.
Different case. Where
No,
is your
same case,
report?
2 co-accused.
So not different case, same case, different accused. So the same report will hold good for both. Report is placed on record by CBI. On prayer of CBI, matter is fixed on Monday. Further report with regard to the status of the proceeding before the Honorable Apex Court be filed on that.
Obliged. Monday.
Yes.
That Iqbalpur matter.
All right. Yeah, victim has been.
Now the trial is commencing. So, whether that condition of not entering it has been more than 1 year.
Now whatever is there will be there. The petitioner is in custody for 57 days. He submits. Petitioner, appellate.
Page 25,
One
26
second.
is the condition. 26 is your.
As a petitioner is in custody for 57 days, he submit co-accused are on bail. There is no chance of abscondence. He prays for bail. Learned lawyer for the state opposed the bail prayer. In spite of notice, nobody appears for the victim. We have considered the materials on record. Allegations against the petitioner is general and omnibus. Co-accused have been enlarged on bail. There is little possibility of trial concluding in near future. Under such circumstances, we are inclined to enlarge the petitioner. Allowed. Condition same.
Page 26.
Page 26. Or out of Calcutta. Not before 4th of June.
There is a relaxation pending with your lordship.
Relaxation all will be taken up 4th of June.
Your lordship is adjourning.
4th of June, all 4th of June. Not before 4th of June. Yes, next matter.
কোথায়? The time in 24 কি অ্যাপ্লাই করছে?
Yes.
That's with regard to the grant of sanction.
Yes, Mr. Advocate. So let him consider.
This petitioners are in custody for more than 20 months.
We'll reject your bail prayer on that. We'll reject the bail application. Because of the influence of the accused persons in custody, the Chief Secretary did not have time to consider 4,000 pages in 1.5 years. That's what we are saying. That is no justification to enlarge you on bail. Mr. Advocate General, please give us a time frame within which he can go through 4,000 pages. We are directing the Chief Secretary to do it. Mr. Advocate General, please understand the Election Commission can have its role. MCC cannot stand in the way because last time the report of the officer was because of MCC guideline I cannot do it. It's not a policy decision.
Every step of paper which is in the election commission, because they directing the past formula in all of the time,
That is far. Mr. Please consider this. This is a case which has been monitored by the High Court. Look at the requirement of sanction. Requirement of sanction is to weed out frivolous prosecution. Now, conviction otherwise is later on. But can you say that the prosecution, which is a product of monitoring by the High Court, is a malicious, vexatious, or frivolous one? Difficult to say. Difficult to say. I won't say that it is impossible. Maybe very remote, extreme situation, one can make out a case like that. But this is not so. Second comes section 19. You don't have to see anything in 19. It's an automatic sanction. Because in 197, you have to see whether it was in discharge of official duty or it was beyond discharge of official duty. Authorities galore, allegations of corruption, by no stretch of imagination, gives the umbrella of cover. This is one. Secondly, as I said, 19 is an automatic sanction. Now, we would have otherwise mandated him to take a decision in a particular manner, but because it's a discretion left to him, we are keeping it open for him. But in 2G case, there was a direction for deemed sanction. We would be inclined to give a direction of that nature, that within 2 weeks, if you don't take a decision, we will direct a deemed sanction in these cases.
Respect. One is that I am seeking some time. Second is, my lord, I would make some research and come back. But whether, my lord, in this jurisdiction, those directions are feasible or not?
Why? We will love you to address us on this. Because the prayer for bail by Mr. Basu and Mr. Ganguly is on the ground of delay. And your officers are standing in the way of progression. There we have the incidental jurisdiction to unlock the prosecution, remove the roadblocks, and thereby examine the prayer for bail in the light of smooth progress of trial. We would definitely not have gone into this issue if the prayer for bail before us was not on the ground of delay in trial. Their main allegation, main submission is, look here, we are, as Mr. Basu said, 20 months in custody. Primary investigation by CBI is over. Maybe some incidental investigation, we will get ourselves acquainted with that. There are a host number of witnesses. Trial is stalled because sanction is not being given. Now, in this situation, will you say that we are exceeding our jurisdiction if we call upon that officer to say, sir, please enlighten us when you are going to exercise your statutory duty? And in that situation, if we see, there are two ways of looking at it. And if that situation, and we made it very clear to your officer on the last occasion, or rather the government leader on the last occasion, and in that situation, if we see that the highest officer of the state is dragging his feet, he's already been doing it for 1.5 years, dragging its feet, we would have to take a call, not on sanction, but on the bail. That these persons, so eminent is their position and so important they are, that they can disable the highest officer of the civil servant of the state from taking a call on sanction.
Well, on the merits of the bail application, I cannot say anything.
Not say anything. Your limited area, Mr. Advocate General, is your officer has a statutory duty to see that the prosecutions conducted in the state of West Bengal are carried out without unnecessary roadblocks and hindrances.
Right.
Now, one of the things which we notice is there is an inordinate time taken by him. And that would definitely, in ordinary circumstances, inure to the benefit of the accused and enable them to get bail. What we need to see is this recalcitrance a part of bureaucratic inertia engineered to derail the prosecution?
Possibly
If that
not.
is so, if we would definitely not say, Mr. Advocate General, we are very conscious of the role of the constitutional authorities, and we will never make a comment with regard to an institution per se. But what we notice here is a species of indolence. And this species of indolence make us wonder, is it manipulated? Is it red tapeism or otherwise? Now, if it is manipulated, we feel in this jurisdiction, we need to pierce that veil and thereafter take a call on bail. That bail would definitely be, but if this roadblock remains, consider, we give them bail and your officer goes on, this is today now, we have got election, tomorrow we have got a 5-year plan program. What takes precedence? Criminal justice administration in the sovereign scheme of things, as much as the democratic requirements of complying with directives of the election commission. So do hand
We have
in
to
hand.
balance. We have to balance.
Do hand in hand. We are giving you as a last chance, how many days? 10 days time to take a decision. If failing which, we are going to issue a rule of contempt upon you.
This particular point also came up before the Honorable Division Bench, Milord, which decided the matter yesterday, and it has been.
We have not gone through that order. We have not gone through the order.
I just had a cursory glance.
Is there any observation on
Yes, sir,
that?
that is,
This is before the court, therefore that bench is not good.
No
Since-
comments passed because it is before your lordship, so they do
All
not
right,
pass it.
so lordships have not
No,
made
no,
any
no.
observation on the issue of sanction.
Just Milord, from 2014, the page 2014 onwards, Milord, what has happened? 2014 onwards.
With regard to the merits.
Hey, merits se bole na, merits se bole. Not on merit.
Page 214. Role of the government, that particular segment. Rather that particular. Page 214. Paragraph 257 it starts from. If lordship takes up.
It's a supernumerary report.
Then with kindly specifically about the sanction is that page 216, paragraph 216. And then it goes on.
What? বলি যে একটা হয়ে গেছে সাংসদে সাংসদে কি বলে কিছু বলেনি পেন্ডিং আছে তাই হ্যাঁ
And it culminates in 264, the observation.
Two 264 টাকা কি হচ্ছে culminate কি বলছে 264 We, however, deem it appropriate to grant leave to seek appropriate directions from court so that since the matter is already before a coordinate watch.
Now, paragraph 264 is exactly the same observations made by us. Two benches of the High Court are requesting your officer to take a decision.
The decision, my lord, has to be taken. I cannot say that. But give us some more time, my lord. I think, my lord, one embarrassing thing, my lord, which I had noted, my lord, just before entering the courtroom, that in the affidavit he says that he's going to consult me.
Definitely he can consult you, he can consult. He should, in fact, no, he can consult whoever he wants. But our question is, let him consult and take a decision on this. We are keeping this next Wednesday.
But may I make this request? Keep it after about 3 weeks. In the meantime, I believe
We can give you maximum 10 days time and keep this matter
on Friday.
no, 3 weeks vacation to test. But
Friday,
I apologize. Because my lord.
No, there is another practical problem is this bench will not be available from 13th of May.
13th May.
Today we are on 23rd of April.
April.
So
10 days. Friday, next Friday.
Well, kindly keep it then after 2 weeks.
Our 2 weeks.
We are keeping on 2nd of May.
Right.
Very well.
2nd of May. And we are passing a peremptory order on the Chief Secretary to take a decision positively by 2nd of May. Right? This way, that way you take a decision.
Well, so far as one of the petitioners, Dr. Partho Chatterjee, against him, sanction has been.
Yes, Dr. Chatterjee, we know. But the thing is, the former school minister cannot be proceeded individually. He is a conspirator. It's an allegation of conspiracy of all. So you cannot, in isolation of Mr. Basu and Mr. Mukherjee, you are for whom?
Mr. Sinha, SP Sinha.
So the two, your presidents of the school service.
I was the president.
Secretary. The minister cannot be proceeded with. Mr. Can you proceed with the minister individually? It's a case of conspiracy. So the sanctions from the state of West Bengal or the from the governor, the appointing authorities, absolutely, or rather, not the governor, the chief secretary is absolutely an imperative. It's an imperative. Achha. Learned Advocate General submits some more time may be given to the Chief Secretary to take a decision on grant of sanction. Stop. Learned lawyers for the petitioner's content, they are in custody for
1 or 2 years.
For almost 2 years. Case could not progress due to non-consideration of sanction, due to absence of sanction. Investigation is substantially complete. Case could not progress due to absence of sanction against some of the public servants. Hence, they may be released on bail. Stop. Petitioners approach this court for bail primarily on the ground of protracted detention and the possible the possibility and as the possibility of an immediate commencement / conclusion and or conclusion of trial was a far cry. The main roadblock canvassed by them was the absence of sanction against some of the public servants. In response, the Deputy Solicitor General intimated the court, intimated us, sanction, Honorable Governor has been pleased to grant sanction sanction to prosecute the former minister of the state. However, sanction at the end of the Chief Secretary with regard to other public servants is awaited. He also intimated that the Chief Secretary had been approached to grant sanction in 2022 but 2022. This required this as ordinarily in a bail application, the court would not have this required the court to issue a notice upon the chief secretary to clarify the position, to clarify his stance in the matter of sanction. Chief secretary submitted evasive reports pointing out election commission pointing out the evasive reports indicating that the model code of conduct is in evasive reports and also referred to the model rule of
model code of conduct I said it's not there.
Chief secretary gave evasive report which did not find favor with the state. Accordingly, by order dated so and so, we directed the chief secretary to take a decision in the matter by today. Presently, Learned Advocate General seeks further accommodation. Presently, an affidavit is filed by the chief secretary, wherein he has stated voluminous documents are to be considered, including the decision delivered by a coordinate bench of this court in WPA 30649 of 2016. Full stop. 2016. Full stop. We are not impressed by the affidavit submitted. We are not impressed by the affidavit submitted with the chief secretary. He was in the chief secretary had been approached by the investigating agency 2 years earlier, in 2022, that is 2 years ago. Full stop. He did not show any, although the allegations involve a large-scale corruption in the matter of public employment in government and government-aided schools in the state of West Bengal, the chief secretary failed to consider the gravity and the seriousness of the crime and did not take any prompt decision in the matter. Grant of sanction. Now, requirement of sanction, it must be borne in mind, requirement of sanction is to weed out frivolous prosecutions against honest and upright public servants. Allegations of corruption, public servants who are tainted with allegations of corruption cannot take the refuge under the umbrella of sanction and resist prosecution. Full stop. It is the requirement of law, resist prosecution. A fair administration of justice requires speedy trial. It is the requirement of law. Sanctioning authority must bearing in mind these facts and ought to have borne in mind these facts and taken a prompt decision in the matter. He has singularly failed to exercise his statutory duty in a statutory duty. Full stop. Accordingly, a statutory duty. Advocate General fervently pleads that a last opportunity be given to the Chief Secretary to take a decision in the matter. Accordingly, acceding to his plea, we direct the Chief Secretary to positively take decision in the matter of sanction by 2nd May 2024. 2nd May 24. While doing so, the Chief Secretary must bear in mind the following facts: : 1. Investigation allegations in the instant case relate to deep-rooted corruption in high public offices. In high public offices. Acts of corruption by no stretch of imagination fall within the ambit of discharge of public duty. 2. Section 19 of the Section 19 of Prevention of Corruption, requirement of Section 19 of the, there is no doubt that the accused for whom sanction is sought are public servants. In such situation, grant of sanction under Section 19 of the Prevention of Corruption Act is an automatic exercise. See Lalu Prasad Yadav Swansu. 3. It is speedy justice under trial. Petition most of the accused, all the accused, the accused are in custody and are awaiting, are in custody for about 2 years. All accused are in custody in these cases.
Excepting one who has been still in custody because it was another.
Accused are in custody in these cases for about 2 years. They have a fundamental right to speedy trial. Chief Secretary, grant of sanction is the stepping stone to commencement of trial. Hence, a prompt decision must be taken. Hence, it is the requirement of law that sanctioning authority ought to take a prompt decision in the matter, lest trial is not delayed / hindered by his indolent conduct. 4. We are conscious that that many of the accused have held high positions in the administration of the state. Howsoever high or mighty a person may be, law is above him. This time-tested motto ought to be borne in mind by the Chief Secretary while taking a decision in the matter. He should not be overawed or influenced by the position, authority, or power of the accused persons who seem to have of the accused persons, and he shall take an independent decision in the matter. He shall take an independent decision in the matter. Stop. Matter is adjourned till 2nd of copy is. In the event the Chief Secretary fails to act in terms of our direction, this court shall be constrained to issue to initiate appropriate proceedings against him in accordance with law.
But kindly make it returnable on the 3rd. He'll decide by 2nd.
He'll decide by 1st. We don't want to keep these matters on Friday.
Anyway.
CBI authorities and shall render Chief Secretary is at liberty to take assistance from CBI authorities if as and when required. If you want any clarification, please immediately give.
They are not.
Yes, we know, but still then we have made it very clear.
I'm great.
I'm grateful.
Yes. Great.
হ্যাঁ
সকালবেলা তো হলো আপনি তো করলেন আপনি যে মামলাটা সকালবেলা এক নম্বর করলেন সেটা তো আর যাওয়া হচ্ছে না লাভ উঠে মারপিট সম্মান নিজেদের যে আমি যাবো না ভাই তাহলে বেশি This order will cover the other cases.
Only one case will not be covered where there is no public servant.
that is item number 38 and 39.
38 and 13. এই এত অবধি যাবে 37 অবধি যাবে 38 39 adjourn till second. Chief Secretary shall submit report on the adjourned.
আর করো না ধীরাজ দা কিছু তো প্লিজ
We come after 5 minutes. After 5 minutes, we come. We have done up to 39. 39. We are keeping 38, 39 on second again. Thereafter we'll consider. 40 onwards will after 5 minutes.
41 is also there, but 41 happens to be Shanti Prasad Sinha. That is the sanction is that is also regarding sanction. Shanti Prasad Sinha, RC. Malad. একদম নাম্বার দিয়ে দেওয়া
but 38 39 adjourned.
Lordships, we have given a Excel sheet indicating all the numbers into it.
But 38 39 is RC6. Well, Lordship will hear it today, my lord has adjourned.
Yes.
My lord, a report was called for the victims have been examined. A few victims are left. The next date is
Till filing of this case, my lord, 4 BG were examined, but none of where my name was implicated. I am in custody for more than 3 years.
now 6 victims are left. My lord, one report is there which I should point out. My lord. Out of 15 victims, 3 victims have been sent to Bangladesh without being examined.
Why?
My lord, the report says that it has come to my knowledge today. And for the rest of the victims, his name has transpired. He was the manager of the Rabba. One victim. I do not have the depositions as of now. And 2 witnesses in the supplementary charge sheet have deposed that
All
this person used to carry on.
A report is placed on record. Some of the victims have been examined. However, others are yet to be examined. Evidence on record shows petitioner was the manager of the hotel where the victims were sexually exploited. In view of the nature of the crime, which has far-reaching social implications, we are of the opinion this is not a fit case to grant bail. Rejected.
34.
Next.
My lord, 35 file is not there. Same case. Right?
It should be of 2020.
23 has come. Yes, sir. 23 has come. That would be 24. I mean, last day I had
All right, 34 we are disposing of. 35 will come up tomorrow. 36.
36. My lord, he is the manager.
So 36 same. He was the manager.
My lord.
Then 34 is also manager.
My lord. My lord.
Both are managers.
Yes, lord.
All right. 36 same order as in
Assistant manager and manager.
who is assistant?
36 is the assistant manager.
36 is the assistant. Huh? 34 and 36 ek hobe. 36 will be assistant manager. All right. 35 not today. But 35 34 এ বলবে no order need be passed. Huh? 34 appropriate case will come up.
35.
35 appropriate case will come up because in this case no order need be passed. Next.
37, my lord.
Yes.
I take 37. I am seeking a day's accommodation. Kindly wait.
Oh, the same order.
No, Lordship, it is different.
No. Supreme Court stay. So Monday. Along with others. Please find out. These are all stayed by Supreme Court. So what happened? You give a report whether they had intimidated witnesses.
Lordship, we have prepared the report. Report is just come.
All right. Monday you give the report along with the status in the Supreme Court.
Absolutely.
On prayer of CPI adjourn Monday. Status of the proceeding before report be filed on that day. Next. 40.
Lord, I am appealing for it. Lord, victim girl is 17 plus.
Next.
I'm for the petition, my lord. The case under section 354C and the section 4 of the POCSO, there is a relationship
My lord, I am appearing on behalf of the petitioner. Allegations are under section 420, 406, 409, 120B of the Indian Penal Code. Read with section 4, 5, and 6 of Rice, Chips, and Money Circulation Schemes Act. Renewal. My lord, more than 4 years I am in the custody. My lord, principal or co-accused, my lord, is already enlarged on bail. So already enlarged on bail. My lord, during pendency of this case, my lord, his bail has been confirmed by this honorable court. But I have the copy.
How long he was in custody?
More than 4 years.
The co-accused.
My lord?
Co-accused.
Oh, co-accused is, my lord, 3 years, not more than 4 years, no, 3 years, more than 3 years.
Petitioner is in custody for more than 4 years. Accused has been granted bail. Accordingly, there is no possibility of trial commencing in near future. He prays for bail. Learned lawyer for CBI submits report and oppose the bail prayer. We have considered the materials on record. Petitioner is one of the directors of of Koilan Group of Companies. The said group of companies had floated illegal money circulation schemes and investment schemes and collected
570 crore, more than 570 crore.
more than rupees 570 crores from innocent depositors. However, petitioner is in custody for more than 4 years. Further investigation is in progress and there is no possibility of trial commencing in near future. Under such circumstances, co-accused, what is his name?
My lord, Apurva Kumar Saha.
Apurva Kumar Saha has been enlarged on bail. We are of the opinion that we are inclined to extend same privilege to the petition. Allowed.
Condition maybe.
Whatever condition with Apurva Kumar Saha, where is the order?
Right.
Next, have you got a passport? Before his release, passport, if any, shall be deposited before the trial. Next.
No hole deposit করবে।
If he is or
the state. The last occasion report was called for. But I am in custody for 3 years, more than 3 years, 38 witnesses, none examined. I am a lady, my lord.
On last occasion, my lord, has been pleased for call for a report regarding the progress of the trial, my lord. The evidence was not started yet, my lord. The charge has been already been framed.
Already charge framed. I have
Charge has framed, my lord. Next date on 9th of
after
July,
proof
my lord.
of charge 6 months after date was fixed. Thereafter, no witness turned up.
My lord, last occasion, my lord, CSW1, my lord, was not present before the learned court. And next date was fixed.
19/7.
Yes, what do you say?
Identified vendor earlier 7 times
The lady, what is the allegation against her?
164 statements are there. My lord will kindly peruse the 164 statement.
The prosecution recently filed supplementary charge sheet. For that, my lord, my trial got stuck.
And my lord, during the crime also, my lord. There was a seizure from his place.
Petitioner is in custody for more than 4 years.
Three years,
More
than 3 years.
More than 3 years, she submits there is inordinate delay in trial in spite of direction given by this court.
First order, there was a direction, expedite the charge.
To expedite the proceeding, recording, a charge has been framed.
Yes.
Recording of evidence has not commenced. He prays for bail. And a lawyer for the state submit. There are ample evidence against the petitioner. 2 witnesses identified her during TI parade examination. Learned lawyer for de facto complaint also opposed the bail prayer. We have considered the materials on record. Petitioner is in custody for more than 3 years. In spite of direction given by this court, there has not been appreciable progress in trial. Under such circumstances, we are of the opinion further detention of the petitioner is not necessary, and there is no chance of abscondence. Is not necessary, but she may be released on bail subject to strict conditions. Petitioner, while on bail, shall remain within district of Nodia until further orders. Report to officer in charge Tehotto police station once in a week and appear before the court below on every day. Grateful. Next.
My lord, I am for the petitioner.
I am for the state inside.
My lord, in this case, the story of the prosecution is that I am the cause of my father's death. Now, my lord, I have been arrested on 25/10/22. That is, I'm in custody for more than 1.5 years. Charge is under 304(1). Charge sheet has been filed. Evidence has started. Now, few things, my lord, I'd like to point out to your lordship, that the prosecution's case is that in the early morning, I entered the house. My father confronted me and I assaulted my father and he passed away. Not immediately. And the complaint was lodged by my neighbor, my first floor tenant. Now, my lord, in this particular case, the mother, who was the only person present there, has turned hostile in her evidence and said that we were fasting because of some puja, and the son has broken a new phone which was given by the father. The father chased him and in the process fell down. My lord, this is the case.
Let us see what the doctor says about the cause of death.
Yes, my lord, kindly see. My lord, only thing is that, my lord, a few things, that I am in custody for 1.5 years. There are 27 witnesses. And one more thing, if I may point out to your lordship.
Petitioner is in custody for 1.5 years. He submits that the most vital witness, that is the mother of that is his mother, has not supported the prosecution case. There is no possibility of trial concluding in near future. He prays for bail. Learned lawyer for the state.
My lord, if lordship will kindly go through the 164 statement of the mother and the deposition of the mother. My lord, it is completely contradicted. In the court, she categorically stated, I did not state to magistrate the entire allegation. My lord, she is, my lord, gaining out by the person. She is the mother. That's why, my lord, he's the son, the drug addict son, my lord.
What is the use of keeping him in custody? Petitioner.
Petitioner. Cause of death is injury, head injury.
That is why. Why should you keep him in custody? Keep him convicted. Petitioner is in custody. Is he suffering from drug addiction?
Yes, my lord.
So what rehabilitation measures are you doing in custody?
Yes, my lord. Rehabilitation. My lord, in the documents, my lord, they have annexed, my lord. Kindly see that.
Correct. So who is going to take care of him if he is released on bail?
My lord, no test with regard to the same has been done.
He was sent to rehabilitation because of the cause, my lord. He abuses his father. This is the
all right. We understand everything, but the question is, if he is released on bail, he will commit similar offense again.
No, my lord, the mother is in a position to take care of him.
Let's stand in with the mother's stand.
The mother
will now hit the mother for money. That is the scope. What does your mother? What's the source of our livelihood?
Lord, they have a house. They
cannot afford the medical treatment. Better you are in custody. We direct your rehabilitation in a proper hospital.
I have a business.
The business. My lord, the son, the petitioner, has a business of his own. He earns from that. And my lord, it's nobody's case that he's drug addicted. He's addicted to alcohol. So my lord, he's 1.5 years in prison, my lord. So I believe that there is a chance that he has already got out of that habit.
He's got more into the habit. Alcohol is freely available in custody.
And my lord, also, my lord, very interestingly, my lord, the complainant, what we are apprehending, the complainant is my top floor neighbor. No, my lord, there is a relevant one. My lord, kindly takes up the FIR. My lord takes up the.
So please, let's not stretch our imagination too much. We understand exactly what happened. You may not have intended to murder, but you hit him on the head and he died. That is all right. Petitioner submit, lawyer for the state submit. Petitioner suffers from addiction and had hit his father on the head as he refused to hand over money. We have considered the materials on record. Petitioner is in custody for 1.5 years. Trial is in progress. Mother of the petitioner has not supported the prosecution case. petitioner, after the incident, petitioner was remained in the room where his father had died. This shows he has no propensity to abscond. There is little possibility of the trial concluding in near future. Accordingly, we are inclined to grant bail. 10,000 to share.
Grateful.
बाप को मारेगा, इसको मारेगा, बाप को मारा है।
Satisfaction কি? কোথায় হচ্ছে?
302 of the Indian Penal Code, read with 3 and 4 of the Explosive Substances Act. On the last occasion, your lordships called for a report as to whether the petitioners stand on the same footing with four co-accused persons who have been granted bail by the Court of Sessions. My lord, they were granted. My lord, the fact of the matter is that the allegation is that, my lord, few persons were making bombs. They themselves had a quarrel amongst themselves and they hurled bombs at each other. My lord, kindly see page 115, the order of the Court of Sessions. There, my lord, 115 onwards, my lord, 4 persons have been granted bail. And your lordship wanted a report to that effect.
There were 4 casualties in the incident. The persons.
4 people died.
4 people died. Interestingly, those all 4 people are the FIR named accused persons.
Charge sheeted also.
My lord, now what has happened, my lord? There is a dying declaration of one of the person who succumbed. That's at page 60. It has been stated in the dying declaration that while manufacturing bombs, one of the persons suddenly started hurling bombs in the.
Who was hurling?
My lord, not named who actually hurled them.
All right. Petitioner is in custody for
1 year, 9 months.
1 year, 9 months. He submits. There is no direct allegation that he had hurled bombs.
They, my lord,
Accused
there are
are
2
on bail. There is no possibility of trial concluding in near future.
It has not commenced also.
There is no possibility. Trial has not commenced. Accordingly, he prays for bail. And a lawyer for the state opposed the bail prayer. We have considered the materials on record. Accused were preparing bombs. In the course of such activity, a fight broke up and one of them threw bombs, resulting in injuries to 4 persons. Who subsequently, all 4 died or 2 died?
4 died. 3 on the very next day, 1 after 8 days. Died after 8 days, made a dying declaration.
And death of 4 persons. Full stop. Co-accused who are similarly, charge sheet has been filed against 26 persons.
12 are still absconding.
Out of 4 have died.
4 of them have been enlarged on bail. No specific allegation is leveled against the petitioner. He stands on the same footing with co-accused who have been enlarged on bail. Accordingly, we are inclined to grant bail to the petitioner.
Deeply obliged.
CJ Malda. I'm deeply obliged.
Next.
On 47, my lord was pleased to call for a report regarding the latest status of the trial. Out of 17 witnesses, 7 has already been examined. This is the report. It's a case of 302.
Materials on record.
Case based on dying declaration.
Dying declaration?
Dying declaration, my lord.
That dying declaration has been proved. Doctor has been examined.
Doctor has been
dying declaration made.
Doctor is one of the charge sheeted witness.
Has he been examined?
No, he has not yet been examined in the trial.
Then, when will he be examined? The petitioner is in custody for more than 6 years. He submits there is inordinate delay in trial. He prays for bail. Learned lawyer for the state submits report. Report does not disclose the timeline within which prosecution proposes to examine the medical officer who recorded dying declaration. Further report be filed on the
Deeply.
When is the next date?
Well, the next date is on the 11th of June.
So 1 week. Next.
Deeply. 1 week. Well, 11th of June.
No, we are keeping it 1 week so that you can tell us where the doctor is.
Whether on the next schedule on.
Yes.
48. My lord, your lordship had occasion to grant bail to two persons in that case of where the rehabilitation was done by the municipality, broken of rules, my lord.
Petitioner submits, co-accused are on bail. You are on the same footing with this.
Except one thing, my lord, when I was in police custody, I allegedly took them to my house and produced a gun.
Produced?
A revolver.
Revolver?
Yeah.
Petitioner submits that co-accused Shravan Kumar Agarwal has been enlarged on bail. The shop, the victims, victims have been, shop rooms have been reconstructed and victims rehabilitated therein. In view of the aforesaid development, we are of the opinion further detention is not necessary and petitioner may be granted.
Great.
Who is for state?
I'm
Next.
Madam, for the petitioner. But there had been pre-mixing with the victim lady in absence of her husband with the landlord.
Ah. Yes.
My lord, more than 3 years, 11 months. My lord, victim has been examined. Out of 16, only 4 witnesses have been examined.
Offense.
6 and 8, POXO, my lord, 376.
On my lord, I am for the petitioner. It's a POXO case, my lord. They were
Yes, Mr. Ganguly.
My lord, I'm appealing for the petitioner.
My lord, I appear on behalf of the state. My lord, I'm praying for not today.
Why?
My lord, I have just received the voluminous CD.
What voluminous? What is the allegation?
My lord, the allegation.
Cyber?
Yes, cyber. My lord, the allegation is that these two petitioners, they are aged about 18 years and 20 years, and another juvenile. They were found in the shop of their maternal uncle Fajar Sheikh, and they were purportedly using the,
When do you want?
my lord, may I only
Day
humbly
after.
pray? My lord, there is a schedule which is fixed today, tomorrow, and thereafter on the 29th.
Wednesday?
Yes.
29th.
29th. So
So we
that's
keep
why
it on-
anyway, in the
We will keep it on
2nd of May,
uh,
the same date
5th of May.
or 5th.
Obliged, my lord.
Date.
Yes, Mr. Banerjee.
For the state, my lord.
302, 234. My lord, a car entered a Bengal bonded warehouse where after a while the night guard saw that two persons got down. They were drinking. Then another two persons got down, and subsequently a body was brought down. A sharp cutting instrument was being used to cut, and then the body was attempted to be submerged. My lord, it looks very ugly. My lord, then what happened was 4 persons were arrested from the spot. But thereafter, many witnesses were examined. 60 total witnesses are there. 61 witnesses are
So
there.
you brought the car and threw out the body.
For 4.5 years in custody. Well, the star witnesses, whoever were there, the top 3 have not named me. They've resigned from their statements, and I'm in custody. So there is no
Others
chance.
are still left. Many of the eyewitnesses
Let
who
them-
identified in the TI parade, they are also left.
Let
The
them
next date is in the month of June.
My lord, may I just say, my lord, humbly, the only person who's identified me is not cited as a witness.
All right, doesn't matter.
My lord, the others are there. So far, my lord.
You give us a report analyzing the evidence already recorded and the evidence that you propose to record
My
and
lord.
the timeline. All right.
My lord.
Petitioner is in custody for 4.5 years. He submits evidence adduced till date does not implicate him in the crime. Accordingly, prays for bail. State shall submit report with regard to the evidence adduced till date, comma, nature of evidence which they propose to adduce, and the timeline within which
My
the trial shall be completed. Matter will appear 1 week. Hence. Deeply. 1 week.
1 week.
হ্যাঁ তুমি ওর 5 বা 6 যেটা বলবে
Madam, for the petitioner, Madam, kindly come to paragraph 6. As many as 10 dates, the victim did not turn up. My lord, he is avoiding.
Only one thing, Lord. What I found from the last order sheet, the victim has already deposed the evidence. Lord, let me place that evidence if you want.
Where is the evidence?
Lord, I have not received it. I have just received it.
My lord,
You are
only
saying victim did
no,
not-
no. My lord,
Yes, there is
17
observation in the order.
My lord, kindly see the only the
Victim
part,
has been examined, yes.
not fully. One day she came and only the part of the evidence has been recorded. I have not get any chance to
custody
cross-examine.
How
More
long
than
you-
2 years.
2 years.
Yes.
The victim examination of the victim is not complete. Learned, he prays for bail. Learned lawyer.
Order
for
the 3rd
state.
of April 2024.
When is the next date?
My lord, next date is on 10/5/2024.
Learned lawyer for the state shall submit report with regard to the status of the proceeding on the adjourned date. Victim shall be examination of the victim shall be concluded on the next date.
That is
fixed
on
before
10th
the
May.
trial court, if not already done.
Yes.
Matter will appear on
the 14th.
14th of May.
Deeply appreciated.
My lord, victim to be notified because she didn't receive.
No, we will notify.
Officer in charge shall notify.
Deeply appreciated.
Next.
এটা রেখে দাও দাদা দাদা এটা নিয়ে নাও না এটা
Wait, please, your lordship. Lordship 498 and 326 3AB. He hasn't assaulted his wife. He went to bring his wife and had a fight with brother-in-law. Brother-in-law assaulted him. I have annexed my injury
You
report.
got assaulted by brother-in-law and
Yes.
you assaulted whom?
I assaulted brother-in-law.
Then
Assaulted with sharp cutting weapon.
Then he assaulted with hand and you assaulted with sharp cutting weapon.
Lordship, I'm sick.
Your son-in-law, so you have right of
No, lordship,
extra
I just
assault.
went to bring my wife and he
What, you went to bring your wife? You went to bring your wife, you assault your brother-in-law. How long you are in custody?
61 days.
Petitioner is in custody for 61 days. He submits. There was a dispute as his wife had withdrawn from the matrimonial home. his brother-in-law assaulted him, subsequently has been falsely implicated. He prays for bail. And a lawyer for the state submit petitioner had assaulted with a sharp cutting weapon. We have considered the materials on record. Petitioner had gone to his matrimonial home. A fight ensued and both parties suffered injuries. In view of the aforesaid circumstances, there is no chance of abscondence. In view of the aforesaid circumstances, we are inclined to grant.
I'm highly obliged.
Well, victim couldn't be served. Malad, out of 18, Malad 7 has been executed.
State? You are for state?
Malad, out,
already
already deposed. Out of 18, 17 has been done. Vulnerable witnesses are complete.
Where is the victim's evidence?
Victim's evidence is Malad, it's certified copy, Malad, in PW1.
Officer in charge shall notify the victim with regard to Gwaltor police station. With regard to pendency of proceeding, next date of hearing, matter will appear 2 weeks hence.
But 2 weeks, your lordship would not be here.
The court will be here, someone will be here. What can be done?
12, my lord. 12, my lord.
All right, 12. 12th is a holiday, Sunday.
12, 11, 10th, my lord. But it
10th of
my lord. Deep.
Someone will know. Someone will be here.
My lord, about 4 years, my lord, I'm custody, my lord. 13 witness has been examined, my lord.
Even custody for another 6 months, then you will get a bigger case.
My lord, there is no eyewitnesses there, my lord. All are the, my lord. Here's evidence.
Bail application. Then you will
only
defend. Either you will get a case for conviction or you will get a notice because acquittal is challenged by de facto complainant. So now nothing to be done. We have petitioner is in custody for 4 years. He prays for bail on the ground of delay. Learned lawyer for state submit. Examination of prosecution witness is almost complete. We have considered the materials on record. Allegations, if proved, would attract mandatory life imprisonment. Prosecution evidence is already complete, and in view of the mature stage of the proceeding, we are not inclined.
And last 1 year, there is no one witness has been examined. Last 1 year, my lord.
Next.
Please, my lord. My lord, the petitioner before your lordship is the husband, my lord. He is in custody for more than 1 year, 7 months. The death was due to suicide by hanging. 9 out of 7 witnesses have been examined till date, my lord. All vague, general, and omnibus allegations.
Petitioner is in custody for 1 year, 7 months. He submit the victim had committed suicide out of depression.
She died within 3 months of marriage.
Within 3 months of marriage. He prays for bail. A lawyer for the state submit 5 out of 7 witnesses have been examined.
My lord, 9 out of 9 out of 17.
21 witnesses total.
Okay.
So I
Submit trial is in progress. We have considered the materials on record. Petitioner is in custody for a considerable period of time. Most of the vital witnesses have been examined. There is no chance of abscondence. Offense, even if proved, would not attract mandatory life imprisonment. Accordingly, we are inclined to grant.
I'm grateful, my lord.
Next.
I am for the petition. Your lordship would remember this matter, that gold loan matter, where everybody was implicated. Standing on similar footing, several persons are on bail. Last one was on 15th April 2024 on 50th day. I am now in custody for 52nd day, 52 days. Charge sheet has been filed. Seven, 9.
All were granted bail on 60 days.
No, my lord. 7 and 9, those were annexed. And my lord, on 15th April 2024, another person got bail. My lord, Shobboshachi Ghosh. My lord, perhaps that, my lord, it's not annexed. My lord, perhaps it would be revealed from a report. my lord, just now I have received this brief, otherwise I would have.
Petitioner contents co-accused are on bail, state shall submit report whether petitioner stands on same footing with the
My lord,
co-accused.
kindly keep this on Thursday, because my lord, in Thursday, my lord, I have another application.
Thursday.
Thursday.
Lordship, actually, I wanted to show one thing. That is, this, I'm being led by Mr. R. Anandi here. I'm his junior.
Huh?
I'm his junior. Who in this thing? Mr. Rudra, I mean, who? Rudradipta Nandi. So actually, what has happened? I mean, he has repaid it. The bank, no due was there on 29/1/2019, and after that he was sitting tight. And 2/3/2024, he was arrested, and he did not come out. And on 4/4/2024, the lower court has observed that they were trying to abscond. And he has not cooperated from 2015, and the bank has written off. There is an unholy nexus between the bank officials and those 194 people.
Those persons are on anticipatory bail. My lord, me and Mr. Probit Mitra was appearing for those persons.
Series will be going on, and typically they are trying to. I mean, today the bank is in ventilator. It's the public money. It's our taxpayers' money.
But he has repaid the loan.
He has repaid the loan, but Lordship, if Lordship comes to page 50, there he has repaid the loan and 55,000. I mean, he has taken 70,000 loan, and overall he has paid 50,000, and 55,000 has been written off.
Written off. So total loan was what?
106. It was coming up. 70,000 was the thing. 2014, he has taken on 7/1/2024. He repaid it.
Bank has come up with a scheme.
2024.
Bank has come up with a scheme that
With 106.
that
Bank is
you
closed
give
now,
you
because
give
it's
me
in
this
ventilator.
amount. You give me this amount. So we'll give up no objection. My lord, those extra amount was actually the interest and others. My lord,
First, you give it. There are a number of persons we have enlarged them on bail, whether he stands on the same footing. Urgent 1 week.
My lord, Thursday, my lord.
Which Thursday?
My lord, this Thursday, my lord, another application will come up, my lord.
Let it come up.
As a
Good for you. Yes, next matter.
I'm appearing on behalf of the state appellant. My lord, this is my lord, is 27 days delay in preferring the special appeal.
Opposite party, madam.
One time.
63 too.
27
Consider
days.
the amendments in the application for condonation of delay. Delay in preferring the application for leave to appeal is condoned.
And
we have perused the impugned judgment.
My lord,
Leave
only
is
on the
granted.
basis of the non-compliance of 52A, my lord, he has been acquitted.
That is good enough. Why should we admit this appeal? Tell us, in view of the Supreme Court decision. Tell us.
But I will.
Leave is granted to prefer appeal.
Grateful.
Next.
Mr. Shumanda Chakraborty appearing on behalf of the petitioner, my lord. This is legal rights matter, my lord. Section 5 is delay in 2 years, 64 days, 46 days. 46 days, my lord.
Delay is condoned. Appeal admitted. Issue notices. Call for record. Revert to pay for suspension of sentence. We have considered the averments and delay in preference. Next.
A relaxation of condition of bail. The last day, Lordship is directed state to inform the victim. But the condition was there. My lord, we kindly come to page 13, last paragraph. On 16/8/2022, condition was there not to enter the district of Malda. Thereafter, your Lordship kindly come to page number 15. I renewed my relaxation of condition of bail. Your Lordship, it was rejected on 18/4/2023 with condition after examination of the said witness, petitioner is at liberty to renew his prayer for relaxation of condition of bail. My lord, may kindly come to page number 29. The witness has been examined and examination is over.
All right.
Page 29, your
Vulnerable
lords will find.
witnesses have been examined. Report is
My lord.
placed on record.
But I have annexed the deposition.
Under such circumstances, condition of bail, that is not to enter.
Page 13. Yes. District of Malda. Last paragraph.
One second.
Page.
Page 13.
Page 13, last paragraph.
Shall not enter the district of Malda except.
This is CRAN 3 of 24.
My lord. Earlier it was
13 is an anticipatory bail order.
My lord, anticipatory? No.
Cancellation of bail.
Yes, cancel. I got anticipatory bail. Thereafter, she filed cancellation of bail.
Let us see
Page 13.
Not to enter district of Malda is and to report to officer in charge of which police station?
My lord, I am reporting the police station.
My lord, I am appeared on behalf of the victim.
You have been examined?
Yes.
Yes, my lord.
Yes.
My lord, last 6 months order sheet.
Where you are residing? No?
My lord, I have annexed the order sheet. This English Nagir Bazaar police station. Page 17.
Nagir Bazaar police station once in a week are waived. Other conditions of bail shall continue. Next.
66, my lord, I am for the petitioner, my lord. But there was condition not to enter into the Municipal Corporation of Calcutta. Page 10 is the order, my lord. Relevant portion is page 11. Page 11, the relevant portion. While on bail shall not enter the municipal limits of Calcutta. That order was passed on 6/10/2023. My lord, I am regularly appearing before the concerned police station at Uttarpada. Page 14 onwards, the compliance report is there. Madam seeking relaxation. The other accused were granted relaxation who were standing on the same.
Condition report is placed on record. Petitioner has complied with the condition of bail. Conditions of bail not to enter municipal limits of Kolkata and to report to officer in charge. Which police station?
Uttarpada.
Uttarpada police station within whose jurisdiction he is presently residing once in a week are waived. Other conditions of bail shall continue.
Deeply.
Next.
What's the for the petition?
Lordship,
Lordship,
number
I
67.
got bail from the Honorable Court on 22nd February, my lord.
Report, file report.
Miss Trisha Rokshit is appearing for the state, your lordship. Today she is not present. I'm praying for not today on our behalf.
Do you hear what we are saying? Submit report with regard to compliance of condition. Inform your senior. Adjourn 2 weeks.
My lord.
Next.
Is a cancellation filed by the state.
Item number 68. I'm for the petition. Opposite party, I'm 1 and 2. I'm praying
For several occasions, they are praying.
the last time.
Huh?
Last occasion, my lord.
They are supposed to file a reply to our opposition. Opposition.
How can you file opposition to your own petition?
To our reply. They have filed opposition. We have
Then-
filed reply in paragraph 4 of our reply. They are supposed to file an
What is paragraph 4 of your?
because during the trial period, the accused persons, they are threatening, and accordingly a case had already been instituted.
Then
In support of that, they are supposed to file their reply, lordship.
what is the condition of bail? What?
Trial is going on, and next date is on May 3rd. 3rd of May.
All right.
This is the letter.
Rejoinder be positively filed on the adjourned date.
Yes, lordship.
Matter will appear 2 weeks after vacation, summer vacation. Report with regard to status of proceeding shall be filed. Next.
My lord, 69, I am for the petitioner. This is that matter where my lordships had cancelled the bail granted to the opposite party number 2 and also directed the registration of an FIR against him for using a forged death certificate in his opposition. Subsequently, my lord, he was enlarged on statutory bail, and again he had used that forged death certificate. I had filed a supplementary affidavit disclosing my complaint addressed to the officer in charge, Mudhumgram Police Station. They were supposed to the state was supposed to submit a report today as to the steps taken on the basis of my complaint.
You go through the report. Any fresh criminal case has been started?
Lord, I have been.
FIR.
Where is the FIR?
Ramajan.
Second bill.
Thereafter, have you arrested them? Report is placed on record. FIR has been, fresh criminal case has been registered. Fresh criminal case being Shamnagar.
Not Shamnagar, my lord. It's Mudhumgram.
Mudhumgram PS case number 245, dated 14/4/2024 has been registered. Full stop. Report with regard to steps taken in the said case be filed on the adjourned date. Matter will appear 4 weeks after vacation. Ms. Ghosh, ask the police to take steps in this case. Huh?
Grateful.
Copy be handed over to learned lawyer for the petitioner. Copy of the report. Yes, next matter.
May please watch it. My lord, I am for the petitioner. My lord,
in charge intimated me about
the accused person, my lord, was not present.
Copy of the petition has not
Nothing.
My lord,
Copy of the petition has not been.
my lord, last two occasions when we served, my lord, it was stated that no such person existed in the address. My lord,
Now he exists.
Now he exists, my lord.
One chocolate.
Yes, my lord.
So give a copy to him.
Yeah, very well, my
Copy
lord.
of the petition be placed, be handed over to learned lawyer for opposite party number 2. Affidavit in opposition be filed 3 weeks after vacation. Reply 1 week thereafter. Matter will appear 5 weeks after
My
vacation.
lord, only one prayer, my lord. If he could be not allowed to enter within the jurisdiction of Godwin Police Station, 376 case, my lord.
Today is the date fixed for charge.
Next.
Sure.
Wait, please, Your Lordship. My lord, I am appearing on behalf of the petitioner. May be permitted to file this affidavit service, my lord.
But I am for the opposite party number 2.
All right. What are you filing for? Why are you filing this case?
Lord,
Cancellation? Huh?
my lord, what has actually happened when the lordship has
What are
gone through the petition?
Offenses? Bailable offenses. Then
Lord,
bail was granted in bailable offenses. In the event there is misuse of liberty, it is open to the petitioner to agitate his grievance before the court who granted bail. With this observation, application is disposed of.
I'm grateful to your lordship. Much obliged, Lord. Clear. Appearance.
Yes, next matter.
Please, my lord. But this is the affidavit of service, my lord. There is a direction for, I think, my lord, there is a leave granted to file counter affidavit, my lord. Opposition, but not been served upon us, my lord. My land was sold, my lord. On the strength of a forced document, my land was sold by them.
Yes.
Why should we grant sell bail?
But see the order, my lord. The way the order was passed, as if it's order of
2 titles
436 order, my lord, as a matter of right, my lord.
Please, you go there and argue all these things.
Well, what I request you, lordship, my lord. Now
18
I
days.
got a copy of this, my lord, affidavit in opposition, my lord.
Based on record, reply be filed 2 weeks after vacation. Matter will appear 3 weeks after vacation.
Most of
Yes.
May please, lordship. My lord, 5th of March, my lord, your lordship was pleased to direct opposition served upon us.
Opposite party number 2, my lord.
But we have not been given a copy, my lord. No, but we have to file a reply, my lord. Opposition is being served today, my lord.
All right, opposition is placed on record. Affidavit reply be filed 2 weeks after vacation. Matter will appear 3 weeks after vacation.
Very well. Deeply.
Next.
All 74, my lord, I am for the 7.
74, 75 actually.
74 and 75 may be taken up together.
Yes.
Because the reason of the order is same. It is a case where
Who is appearing? Opposite party is not there. Fresh notice be served upon opposite parties to raise the speed post with acknowledgement due, file affidavit of service. Matter will appear 4 weeks after vacation. Next. $76.
My lord, appearing on behalf of Enforcement Directorate. My lord, this is our application praying for cancellation of bail of the accused 76. This is connected with my lord MPS matter, MPS group matter, so Ponzi scheme matter, my lord, so it will come before your lordship. But the date
Only give notice upon the opposite party through registered speed post with acknowledgement due, file affidavit of service. Matter will appear 4 weeks after vacation. Next.
Same, my lord, same.
Same order.
66, 76 and 77. It will give.
So I'm for the appellate.
Both.
No, 79, you also appointed Mr. Das. Also, you heard this matter.
All right, we'll keep it after 2. After 2.
Let's.
Other matters at 2.
Thereafter. I was absent. No, subject to personal lordship, though I can't take the entire advantage, but at least when the same witness না
Yes.
Notes, my lord, we are filing our notes. The lordship, my lord, allowed us to put in the notes, my lord. My lord, it's, my lord, just been stitched, my lord. In a few minutes, it will be in court, my lord. Kindly pass it on.
We have made our submissions, my lord. I think it's.
Yes, my lord, only, my lord, on one point, my lord, that, my lord, the 100 crore threshold of SEBI, my lord, I would just like to place that provision. My lord, for your lordship's consideration, my lord, if your lordships, my lord, allow, just, my lord, that one point, my lord, on law, my lord. Whether, my lord, it has to be, my lord, a cumulative sum of criminal complaints, my lord, which have culminated into charge sheets, or whether it is just the money pooled by any of
You
the.
inform us whether SEBI has taken action against this company or not.
Not yet, my lord.
Okay.
Not to our knowledge, my lord.
We'll consider that. You make your submissions. Pass to.
Item number 78 and 79.
78, 79 is passed to. Appeal bill. Very good. Paper books be prepared, positively prepared and placed before this court on the adjourned date. Matter will appear 2 weeks after vacation.
14th May is the date fixed for evidence, your lordship.
For what?
That is what I've been instructed, my lord. Oh, I about on your lordship said something different, my lord.
Hmm.
My lord, I am for the appellant petition. my lord.
Page 25, my lord, the earlier rejection.
My lord, I am renewing my prayer. My lord, I am in custody for 5 years and 6 months. My lord, initially I was taken into custody in connection with the proceeding under section 25(1)(a) of the Arms Act. While I was in custody, I have been implicated in connection with the NDPS proceeding which is initiated earlier. Now, my lord, once I was in custody in
52A has been complied with.
My lord, 52A, my lord, there is and the only thing is this, my lord, the while I was in custody in connection with that case,
for in further recovery, this present case has been initiated from a house of another person who was implicated as an accused. Admittedly, that was their house, and he has been acquitted from these charges, millet.
Paper book is also ready, my lord, and earlier rejected, my lord.
No, earlier rejection long back.
52 is complied with.
52A, millet. The only difficulty is this, that it's not clear from the judgment. And the inventory, there is no inventory, millet.
I think entire consignment.
No, millet, there is an inventory. There is an inventory.
Entire consignment went.
No, millet, there is an inventory. There is an exhibit 6, millet. There is
Exhibit 6.
Exhibit 6 is the inventory, millet. But my humble submission, millet, if this recovery, this should have been the subject matter of that case where I have been in a custody, millet. Millet, this giving a new cause of action and
That is nothing. That's a very technical submission.
The issue is, millet, I am suffering two separate prosecutions. In that case, millet,
that is not an NDPS case.
That is an NDPS case, millet. Initially, I was in Arms Act. I was taken into custody in connection with an NDPS case. In the NDPS case, while I was in police custody, another recovery. And on the basis of that, a separate proceeding, millet.
All right. And in that recovery, who are the witnesses to the recovery? Where was the recovery?
Recovery is from the house of one Zakir. That is the house which is in the name of a deceased of the father. Now, the Zakir has
his father means
of Zakir.
Right.
Now, the Zakir has been acquitted from this case.
Zakir has been
acquitted. Lord, she would kindly come to page 75 on the premise that his name came in only on the basis of the co-accused statement.
But the houses of Zakir.
That is the. Lord, she would kindly come to the page 75, millet.
All right. Any independent witness to the recovery?
No, millet. Though two independent witnesses were there, they have been declared hostile.
Appellant is in custody for more than 5 years. He submits recovery was from the house of one Zakir Islam, who has been acquitted. Nothing on record shows that petitioner appellant had control and custody over the place where the recovery had exclusive control over the place where the recovery was made. He prays for bail. He renews his suspension of sentence. Learned lawyer for appellant contends recovery was made on the basis of his disclosure statement.
108 bottles of offense.
Disclosure statement to PW?
Disclosure statement to PW1.
If I are
the person who invested.
No, PW1, full stop. On his showing, presided syrup containing narcotic substance of commercial quantity.
108 bottles of offense.
100 bottles of
108 bottles of
108 bottles of presided syrup was containing codeine phosphate of commercial quantity was recovered. Appeal is ready for here. Paper books are prepared. Bail prayer for suspension of sentence was rejected earlier. Paper books are ready. We have considered the evidence on record. Recovery was from the house of one Zakir Islam. Said Zakir Islam has been acquitted. Disclosure statement, recovery pursuant to disclosure statement is not supported by independent witnesses. Appellant did not have exclusive control or possession over the place from where recovery was made. These aspects, he is in custody for more than half of the sentence imposed sentence imposed upon him. Paper books, though paper books are ready, there is no possibility of the appeal. Appeal pertains to 2021. Paper books are ready. Appeal pertains to 2021, and there is no possibility of it being heard out in near future. Under such circumstances, we are inclined to suspend this.
মানে satisfaction লিখে দিচ্ছি লিখে দাও
How do you prove possession? Where is possession? You are proving, what are you convicting him for? Possession. So that possession, there must be constructive control over the place. Where is that?
Statement, sworn arrest.
If you acquit Zakir, you cannot convict him for possession.
He has been ownership of the in the name of the job.
What does the disclosure statement prove? That he has knowledge that narcotics is at place A. That may fix him with abatement, but will not fix him with possession until and unless it is his house or he had exclusive control, he had the key over the land or something.
লিখে ঠিক করে লিখে দিয়ে দুইটি কমপ্লিট হচ্ছে রাখো ওখানে
Yes, next part.
Yes, my lord. I am for the petitioner.
I am for the victim appointed by High Court legal.
Stated.
Where is the appellant? Appellant not there.
I am myself. I am for the petitioner. The appellate petitioner be convicted, my lord, under section 376.
PW1 is convincing.
My lord. No, my
Yes.
Yes, PW1, my lord. He stated in her 160 post and otherwise, my lord. But and PW2, my lord, who is the FIR maker, my lord, he has failed to corroborate his FIR, my lord. And kindly see, my lord, hard 161, hard evidence, my lord. She was declared hostile, my lord. Yes, my lord. My lord, I am sorry, my lord, I have underlined the portion, my lord. From Chatterjee's
Who did not support the case, you say?
Yes, my lord. De facto complaint. She is the FIR maker, my lord.
3 at page 11. She is the sister of PW.
And we see, my lord, the evidence of PW2 and defense witness number 1, my lord.
What is the sentence imposed on you? 20 years.
Foxo, my lord.
Sentence? 10 years.
And
Well, 307, 326, 10 years. Well, term imprisonment. I was always on bail since 2010. FIR was lodged after 32 days. The incident speaks about one person throwing acid at the back, and that was the injury which caused, and as a consequence, 307 and 326.
326, right? Not 326A?
No, no, I think in 2010, Mala, it was not there.
2010.
Yes, that's why I'm telling you, Lordship, but it may not be there at that relevant point of time.
Your Lordship kindly comes to the
Injury.
victim PW2 at page 16.
Well, for 32 days, he did not name anybody. 5 doctors were examined. He did not name anybody. He said by unknown miscreants.
But my lord, before the wife and one independent witness, which is PW3, he could name the assailants.
Not before the doctor, because that was named after 32 days. Not a term imprisonment, Lordship will. Thank you. What's this for? 32 days. No, he died the problem. Page 16 of the judgment. The GT entry on the day itself question. Topic no number.
How long you were in custody?
Now, 1.5 years. December 22.
Appellant is in custody for 1.5 years. He submits. The victim did not name his assailant before the medical officer. He was subsequently was falsely implicated. He prays for suspension of sentence. Learned lawyer for the state submit victim had named the appellant to his wife and others. We have considered the evidence of the victim. We have also considered the medical evidence. The sentence is one of term imprisonment. Good stop. Appellant is in custody for 1.5 years. Paper books are not ready.
Paper books are ready.
Have not been
ready.
Oh,
Paper
paper
books are ready.
then we'll fix it for hearing and debate.
What? Well, Lordship sees it is taking so much time otherwise. Paper books are ready. I don't mind doing it with your Lordship. But please. Please, Bala, please. Please. Bala, please.
We'll keep it after vacation, latest consider. After vacation. Come back after vacation, please. Not now. Well, this is a clear case. We can give you some concession on safety.
Well, I'll tell Lordship one thing. Your Lordship, I'm not on that. But I have never seen, this is my 41st year, a judge giving 51 judgments of his own to convict this person.
51 judgments? Yes.
Of his own.
Oh, that Tahsildar Singh and all that.
But just sees
Good. He is
But
researched.
51 judgment on his own to convict this person.
He has researched. What can you say? A person takes effort to research and give a judgment. What is the difference?
No, at least but if it was a balanced, I could have appreciated.
No, we have seen the judgments are essentially on the point of contradiction. You have seen
True.
80%.
Your Lordship, what was the last order Your Lordship passed just now? Adjourned.
Adjourned. After vacation.
Malad, after fifth, well, from fifth, I'm being admitted on the sixth, Malad, in Coimbatore for a shoulder injury, Malad, of May. So,
all right, so we keep it
1 month I am after vacation.
2 weeks after vacation.
Achha. Grateful, man.
After vacation.
Grateful, man.
On 84, my lord, I am tendering my apology, my lord. It is my fault, my lord. I missed it, my lord. Can it be taken about tomorrow, my lord? I have missed the vacation.
Well, this matter is supposed to appear on the 10th of May. Lordship kindly comes to page 15 of the application.
Application has been disposed of.
Earlier application.
Earlier, it's renewal.
January.
Renewal.
Lordship, let the matter appear on 10th of May.
10th of list on 10th of
10th of May.
Paper book is not there.
Oh.
এটা তো রয়েছে আপনাদের annex করে।
না না আরে বলতে পারছি না।
Fix on 10th of May, lower court records be placed positively on that day.
Yes, madam. I'm grateful. It's my fault, madam. I do.
There is no suspension of sentence possible for you. We'll consider the preparation of paper book at the
Let me try, madam, my last.
No, you try your luck now, we'll reject it. Prayer for suspension of sentence was turned down in January 2024. We find no reason to reconsider the prayer at this stage. Lower court records be placed before this court positively.
Not initially, madam, only one thing, madam. When the matter was admitted, but it was for 8 weeks to prepare the paper. Thereafter, the bail was turned down. Another 8 weeks, my lord.
Yes, so
my lord, till now, my lord, I'm in custody for more than 9 years, I think.
So we'll consider. That's why we have kept it here. Next.
All right. I'm grateful, madam.
Item number 8 to try. My lord, I am for the petitioner, my lord.
No, the victim has been notified or not?
The victim has been served, my lord. This is my affidavit of service. My lord, the conviction under section 6 of the POCSO Act, my lord, for a term of
It
My lord, the victim was all along consistent with her statement. That is true. My lord, though there are minor discrepancies so far age is concerned, she stated 20, but my lord, the admission register was produced. It was marked as an exhibit, which is 14. Now, my lord, only thing, my lord, if your lordship finally comes to page 32 of the judgment, paragraph 15, my lord, the charge has been altered from 6 to 10, from 10 to 6. Now, the trial was
And I am for the petitioner, my lord. The victim has not been served, my lord.
victim be served. Lower court records be positively filed on the adjourned date 1 week after vacation.
Grateful, my lord.
Yes, 2 p.m. Appellate. সব ওই bill গুলো। Where are they? We'll keep it tomorrow. I think it's something inconvenience, Mr. A. Lakwani. Lakwani appears. Where is Lakwani? He asked for time, no? If he is inconvenienced, we can keep it tomorrow. Tomorrow, আমাদের কালকে কিছু আছে?
My lord, written notes of argument has been prepared. May we please?
What we are saying is, if your counsel is inconvenienced, we can keep it tomorrow.
I will be saying Friday.
Friday.
Not Friday. Then we have to keep next. Then Friday, we have some personal deal.
Next week, my lord, if it is possible.
See, tomorrow is available. Thursday, all right, Thursday we can keep. Thursday, what is this?
Thursday.
Tomorrow you have difficulty, so we keep it either on Thursday or Monday. Monday.
Monday.
Monday, Monday.
My lord, but may we submit the written notes which we have prepared?
Circulate it.
Okay, I am having the copy. I'll circulate.
Based on record.
Yes.
Keep it on Thursday, Mr. N. Bhattacharya will be not there on Monday, my lord. Might be there some difficulty.
Tuesday?
Tuesday, much obliged.
Mr. N. Bhattacharya is available on Tuesday?
My lord.
They have some difficulty today, written notes they are filing.
My lord.
Take a copy of the written notes. We are keeping it on Tuesday. All right.
My lord, for orders, my lord, I don't know, my lord.
They will make some submissions.
Yes.
Their submission, they have made a written note.
Very well.
Through it. If you want to make any comment on the written note, you may. We will hear them because we do not know what is there in the written notes. All right. So keep it on Tuesday because tomorrow I think the public prosecutor has some problem. Friday is not possible. Thursday we have to take Ponzi matters. So we keep it on Tuesday.
Tuesday. Okay.
Next Tuesday.
If it
But if the rest of the at least.
But only one request, my lord, the rest of the matters, my lord, is it my lord's pleasure, my lord, that they should also come up, my lord, on Tuesday, my lord, after this, my lord.
May come up Tuesday, but Mr. Banerjee, we may not be able to dispose of all of them Tuesday.
My lord, I my lord, fully appreciate that, my lord. Only
We will
difficulty.
keep it all the matters on Tuesday. এই অন্য মামলাগুলো Tuesday তে রাখো. But we will first dispose of these three.
Very well, my lord.
What
Very
we
well.
have said is we will dispose of in batches, right?
Very well. Yes, my lord, that's what, my lord, my submission, my lord, also would be, my lord.
Yes. So
because if, my lord, we are at all successful, then, my lord, we, of course, my lord, has to be successful in, my lord, all, my lord, for us to, my lord, be released.
I'm sorry. Notes?
The notes are circulated.
Yes, my lord, just, my lord, that one provision, my lord. If your lordship kindly, my lord, takes section 11AA of
Tuesday make your submission.
30th.
All right. Further hearing. We'll keep on Tuesday. We have kept your records. You make your submission on that. You also intimate, Mr. Banerjee, please intimate us whether SEBI has initiated any proceedings against.
No, my lord, they have, my lord. They have not, my lord. We have, my lord. They have not initiated, my lord.
We'll see what you are making your submission.
So,
Because
okay.
in the these Ponzi matters, we refer them only when the loss suffered is over 100 crores. Without that, we don't refer because SEBI lawyer said that without crossing the threshold of 100 crores, they are not invoking the SEBI Act.
my lord, but my lord, that would have to be ascertained, my lord, from perhaps, my lord, the material which is on record. And my lord, the material on record.
There are two aspects, as you rightly pointed out. There may be other persons who had also suffered losses. Now, SEBI has not made an inquiry on that and initiated proceedings. One. Two, so far as we are concerned with the loss in the criminal cases.
Yes.
And that is below 100.
That is below 100.
Correct. That is below 100 crores. You argue that No, this is not the total corpus of loss. Total corpus of loss may exceed 100 crores. Even if that is conceded, SEBI has not initiated any.
SEBI has not
So
initiated.
we'll factor in that. You make your submissions, we'll factor in. Please make your submissions on whatever aspects you want to do so that you assist us in passing the order.
We're so grateful, my lord.
Tuesday, 2 p.m. Okay.
Very well.
This, এই ওই মামলার ওই স্কুলের মামলা টিউসডে নয় তো?
অন্যগুলো ছিল। The others, my lord, will give the, I think they're not in the list today, we'll give the numbers. We'll
Other
give the
matters, Mr. Lakmani, you are in appearing other matters.
My lord, I am told, my lord, I'll be appearing in 2 more.
What we'll do is these 3 definitely Tuesday, please be ready. Mr. Public Prosecutor, be ready in these 3 matters. Then the next set we may be keeping on Thursday or something because these are Ponzi matters. So we will keep them on Thursday and deal with the next set where you are appearing. Then we will consider the others.
Very well.
Okay?
Very well.
Grateful.
Item number 78.
No, deal with it. You did it. Funny, yeah. So different. Mr. We have understood there is a very recent judgment of Justice Padiwada on contradiction and what happens if a vital piece of evidence which needs to be contradicted was the only way where we look at Mr. Chatterjee's case is to remand him for controverting, right? So we want you to go through that judgment of Padiwada, Justice Padiwada, and then make submissions, right? Just give you the citation. Okay. Very recent judgment in 2023.
23.
Exactly like your case, the vital contradiction was not taken. Their lordships have given the opportunity of remand. The only way you can protect your client is to remand and have Mr. Das's evidence controvert the witness. Isn't it, Mr.? Otherwise, we cannot look into that other evidence. So we can do that. We can uphold Mr. Das's, we'll hear Mr. Das's point. If Mr. Das makes out a case for acquittal, so very good. If not, we convict him, and so far as he is concerned on the point of contradiction, we remand. Because subsequent evidence you cannot contradict.
Justice Control as well, contradiction in evidence, remand.
I made a mistake. Why? I don't know. May not be. Yes. We'll, please look into this and find out. I've not been able to find out. There's a recent judgment on the contradiction, particularly failure to advert contradiction, and whether that gives the right to the appellate court to remand it for consideration on the point of contradiction.
Yes, previous trial statement, statements recorded in writing of the witness. So that can be placed for contradiction.
But prior evidence in another case can always be used to contradict a witness to the other case. But here there is no contradiction in this case. Right. Find out this. Or when do we keep it?
After vacation.
After vacation. Huh?
The group clash between two groups. In one group, 2% died. This group, this person. Now, here the accused person didn't suffer any injury. But the genesis of the prosecution case has not been stated, has not been spelled out properly. Because it has come into evidence that the clash between two groups resulted into 3 deaths. 2 days.
Was there a case counter case?
No, that is not referred in this judgment or in this case that there was any counter case. But it has come in the evidence that yes, that was a clash and 2 persons of that group died. And
case was
1 person of this group died. The wife of this person is the de facto complainant in this case. So there is a clash. And that is all judges also considered to that there was a clash between 2 rival groups.
Where is your appeal is?
79.
No. Mr. Das's appeal?
My appeal is 388.
388.
Of 2012.
388 of 12. Let us consider that first. This is online. This is online. Which year is given? Recent, no? Our internet with.
This number, NSC number is 7.
NSC is 7. We went where the SSC. Oh. I think this is monopoly. EEY. Funded? Yes.
September.
Hey, internet connection না এখানে? দেখো ইন্টারনেট এটা কোথায়? হটস্পট।
Yes, sir. Please, 10 years.
Not the presiding officer. Any remarks? That's what I'm saying. It is, brother has brought it out, is 223 INSC 793 Munna Pandey versus State of Bihar.
Hon'ble Munna. MUNNA.
Munna Pandey versus State of Bihar, criminal appeal number 1272 of 2018. And
State of Bihar.
2020-23 INSC 79.
It is on contradiction.
This is where earlier statement contradicted was not done, and on that ground the court remands it. So, if that is so, that would give us an occasion, so far as he is concerned, to remand him with regard to this statement. But with regard to your case, we have to go into the merits. So we can keep it next week. You bring Munna Pandey, on that basis we can remand your case. Huh? Monday we keep it. This Monday? Monday. Heard for the hearing Monday. Monday. I mean, leaking. No, I noted. It's on the server all the time. It's in the CC database.
একবার লিখে দিয়ে চেঞ্জ হয়ে গেছে 78 লিখে দিয়ে দে না একটা চেঞ্জ হয়ে গেছে ও নিয়ে চলে গেছে একবার নামটা
আমারটা দিতে সোমবার হালকা দিয়ে লিখে শাকের সাথে আর
ঠিক এটা আগে হবে ওটা তো শুনানি হয়নি এইটা আগে হবে এটা শুনানি তার তলায় yes call other matters
Grateful, Lordship.
ডেকে দাও নট দিস উইক করে দিই
For my mark list. Towards 121, 153. 125, 126 and 127, 128, 131, 132 and 133, 100. One hundred 146, 147, 160.
So 157. Also, may I be permitted to pray for fixing any day, Lordship, as per your Lordship's convenience, any day, in a daily supplementary list. But sir, we are for the appellant. I am led by my learned senior, Mr. Ashok Banerjee, sitting in bus room number 5. Lordship.
no one appeared
ওইটাতে
নাম আছে আর
191, 192, 106, 207, 223.
Mala 207 on the last occasion, Lordship, I had mentioned this is a matter NDPS Act, Your Lordship. 52A, Your Lordship. Shimon, there is appearing here, informed him on the last. Shimon, there. I'm grateful, Your Lordship. I'm grateful, Your Lordship. 107. Shimon, there. Shimon, there.
224, 137, 238,
267, 268, 282, 283, 296, 297, 311, 312, 327, 340, 343, 357, 358 to 371, 372 to 379.